go ahead and get started. Thank you all for being here in the Launch Lab this evening for our event, and hopefully this should be very educational for you, because the intellectual property process and the patenting process it's complicated, but it's very interesting. And I know Mr. Smith will be accommodating for you if you have some questions about your particular process. But I wanted to just do a quick introduction and then let him get started. And then, of course, as you have questions as we go through, they will be welcome. Attorney William Smith is, his primary areas of practice are patent law and intellectual property law. And I'm not going to go through the whole bio because it's very, very, very extensive. But I laid some around the room so that you can see what his background is. It's quite impressive. His education is, he has an engineering degree from the University of Pittsburgh, and his law degree is from Duquesne University School of Law. And he's a member of the Pennsylvania Bar, United States Patent and Trademark Office, and every other certification and requirement that can be imagined. So, Mr. Smith, will take it away.
Okay, please. Yeah, my name is Bill Smith, and you get all these qualifications, the older you get, they just accumulate them. But I'm with Spillman, Thomas & Battle. Our law firm is based out of Charleston, West Virginia, and our IP group, which is now, as of last week, just me until we get a new trademark person, is based out of Pittsburgh. So we find there's more technology-based companies in Pittsburgh, although we like to explore West Virginia and try to develop more entrepreneurial and intellectual property-based companies out of here. So there is a lot of technology in WVU. We just don't see the patenting activity as much as we do up in PA. So, as Carrie said, my background was an engineer. I was an engineer for 12 years before I graduated from law school and started practicing law. And now I've been doing intellectual property law for about 30 years. So I think I've seen most everything you have seen in that area of practice. So I'll be happy to answer any questions. I'm curious with this group, and I brought actually two presentations. The first one that I have up here, Intellectual Property Basics, probably a good primer for people who are just like yourselves, just getting out of college. And I don't know if you're primarily business oriented, or are you engineering or technology oriented. How many engineering undergrads do we have here? 2, 3. Anybody write a patent application yet? And you have?
I have.
You have a patent?
I have a patent.
What's your patent?
My patent is with, it's a design patent for gloves
Okay.
that have a W and a P on them.
Okay, that's interesting. Well, we'll cover some of the design patent information. And how about yourself?
It's a mechanical patent. It's a book holder that mounts inside a cabinet.
Okay, good. So we have a little bit of experience with that. How about business majors? Venture capital people here, or aspiring venture capitalists?
Not yet.
Yeah, not yet. It takes a while. So you really have two competing interests, but different focuses, I think. The engineers are primarily, when I talk to them, interested in less in the business and more in the technology side. So that is directly geared towards getting patent protection on technology that you develop. And you'd be surprised, because you have the advantage at this age to be working with professors and labs that are pretty sophisticated. And I remember when I was in engineering school, myself and a few other guys who developed things thought, well, it's a good senior project or whatever you're doing, but not realizing 2 years later, wow, you've got a patent on it. It might have been valuable. And even back then, we were working on a lot of software stuff. And I say back then, I graduated in '77, and I did a couple years of postgrad, or we should say master's level courses. But software back then was considered to be unpatentable per se. You couldn't get a patent on a computer program. Now, people are fighting left and right over technology that's primarily based on software, whether it's embedded software in a chip, or just lines of code that are written to perform the same function. We'll get into some more detail on that. And then, on the flip side of that, when I work with investors, they like to know a little bit about the technology, but they're more interested in the business aspects of the licensing, the ownership of the technology, the value of that technology. They might have us review substantively to see if during prosecution some of this technology was correctly examined, properly examined, because they don't want to find that they're buying a company with invalid patents. So, you know, you can get it, particularly you're probably well familiar with Mylan Labs, generic drug manufacturing, and there's a whole area of law just directed to litigation on the drug industry, on Orange Book drugs, and they spend a lot of time investing in those patents. And certainly when companies go off patent, the brand name companies, they're probably generating $1 billion a day of revenue worldwide. So they will fight tooth and nail to extend that patent term as much as they can, and they get 6-month extensions for orphan drugs, 6-month more extensions for, not orphan, I think juvenile or something like that, for applications where the drug may not have been originally intended for treatment of juveniles, because there are special bioequivalencies that they have to work out for the dosages. So anyway, that's a little bit of background, so why don't I just get into the presentation. And I would encourage anybody to ask questions. This is sort of a rigid format for PowerPoint, but I'm sure you'll have some thoughts, and feel free to jump in at any time. So we can do with an overview and IP rights. Again, it's sort of on the investor side, what the capitalization of the intellectual property that they've invested in. So these types of property, I'm sure you're familiar with personal property and real property, otherwise known as tangible property, and then the intellectual property is intangible, which is what it sounds like. You can't touch it, but it has real value, real monetary value, and is traceable through recording at the patent office and assignments and licensing agreements, so that even though you can't touch it, you can read it and you can understand it, and it can generate a lot of revenue. So the 4 main types of IP, patents, we just talked about a little bit. That we'll get into in more detail, but it's really directed to the technology. It can be directed to designs of products, and special types of plant patents are also available. Copyright is, again, you've probably dealt with online, downloading and issues related to basically ripping off music and things like that. That's all based on copyright law. You can register copyrights. You do not have to register copyrights in order to be able to protect them, but you get statutory enhancements that are important sometimes when you may not know how much money you've lost because of somebody infringing your copyright. But if you have a statutory registration, you get the advantage of up to, I believe it's $30,000 per infringement, and that is per infringement, every single incident. So every single download is available up to $30,000. That does not mean that you're going to get it, but you can ask for it. Also, you can get attorney's fees and costs of litigation if you prevail. Trademarks are branding type of things. You register your trademarks like Nike or Apple. You've seen them, and surprisingly, I get some confusion between those. I'll have somebody who'll call me and say, I have an invention I want to get a trademark on, or I'll have I have a new design I want to get a patent on. So to me, I work with it every day, so I don't know how people confuse it. But certainly, if you've never dealt with it, you can get confused with that. And I should say that trademarks are also capital assets that can generate a lot of revenue and have value in themselves. So you'll see sometimes companies going bankrupt even, and the sole assets they had to sell were their trademarks, and there'll be some significant bidding. Recently in Pittsburgh, Nabisco, when I say recently, it's been a few years now, but they sold off a lot of trademarks on, I think it was Little Debbie's and things like that, but, you know, companies are willing to pay for that. I'm sorry, did you? Twinkies was another one that generated a lot of revenue. So there's a lot of value in trademarks as well. The last one, trade secrets, are also a valid means of protection. The most famous one would be, I guess, the formula for Coca-Cola, which is still protected as far as I know. About 10 years ago, a friend of mine who was an executive at Pepsi was telling me that they got the president of Pepsi, CEO, received an anonymous envelope and opened it up and said, here's the formula that you've been wanting to get from Coca-Cola. They actually sent it to him. The guy closed the envelope, called the president and CEO of Coke, and said, I got this from one of your people. I haven't looked at it. I'm not going to look at it. Come and get it. so it was probably the right thing to do. But he may have, yes.
So if you have a patent, do you also need to have a copyright, or is it just
You
okay?
can do both. There are different types of protection. It often comes up in software where there's functionality that can be protected more broadly by a patent. But you may also want to make sure, call it belt and suspenders, that you can file your copyright for the computer program. And there are several different aspects to a computer program copyright, which would be the source code, just the lines of code explaining how, explaining that execute it. If you execute on the computer, it will operate the program. But you do not have to include all of the source code. And what we typically do is the first 25, last 25 pages are part of the program, but we tend to load it up with documentation and things that don't include proprietary secret information. You may have algorithms in there that nobody else knows how to use or can use. You can redact those when you file them, so that even if somebody does get a hold of your copyright application, they won't be able to see what the real gold that's inside here is. But the safe way is just to front load and back load 25 pages, which is all you have to file. And we always like to throw in our grandmother's telephone number, birth date, in the comments, so that if somebody would happen to copy it, we would know exactly how they found it. And, they wouldn't have no other way of knowing what my grandmother's birthday was. So there's a lot of tricks with that. But that's software copyright, and then the functionality can also be, the program can also be included as part of the patent application. We don't normally include lines of code in a patent application, although you can. But in the patent application would be more directed to describing the steps, the functionality of the program, and leave it up to a code writer to carry out the steps. But on the trade secret side, it's a legitimate way of keeping the secret, like Coke was successful for so long. The issues that you run across is you have to keep it a trade secret. You have to always treat it as a trade secret. You can't, anybody who would have access to those trade secrets would be on a need-to-know basis only. So you just can't leave it laying around the office so that everybody can pick up a book or copy it or whatever. And a lot of times, the companies don't have the discipline or the wherewithal to really track that stuff. So it has to be protected that way, or you're basically invalidating the trade secret anyway. The other thing is, trade secrets will go on forever, but if it can be reverse engineered, there's nothing to prevent somebody from doing so, and then your trade secret is blown. So in the case of Coca-Cola, I guess, even though you know the chemical makeup of it, you don't know how they went about producing it, so that secret was able to be upheld. And primarily I deal in electrical, electronic, and mechanical devices, and most engineers can reverse engineer pretty much anything that they can come across. You may be, if you're taking electrical courses, a lot of the, not even printed circuits, just the circuit devices will be embedded in this amber liquid or whatever, resin, which is partially to prevent people from reverse engineering, but even then they can still, they might destroy it, but they'd be able to cut through and figure out how the circuits are wired. So that's the advantages and disadvantages of trade secrets. Aware that, brand awareness, proprietary information, all has an inherent intrinsic value to a company. So we call it barriers to entry. So if you want to get into some sort of electronics field and just run with it, you cannot start without getting either licenses to the technology or searching it, or you run the risk of being sued for infringement. Patent infringement is a very expensive process, and it's no fun. The ones that you see on the news are typical: the Apple and the Samsung and the Texas Instruments, and basically large corporations that have a lot of stake and they have the resources to fight those cases. So you protect legal interest in goods and services. That would be the trademarks that you have, and preventing knockoffs and counterfeits. As I said, the intrinsic value is the ability to sell and license those. It's nice when you can get royalties for your intellectual property, your inventions, and a lot of companies have sort of a side group that picks up technology of things that is not in their core business, but it's sort of spin-offs from stuff that their engineers are working on and it's still worth patenting, and they'll try to license that. And a lot of universities have technology licensing groups now that do the same thing with technology that professors come up with in patent. So there's your competitive edge, the innovation, and the market stuff. Now, what is a patent? It sounds like an obvious question. We just talked about a little bit about it, but there's a very strict format that you follow in a patent application. A patent, once it's issued, they're not very entertaining reading, but they're very technical documents, and they're constructed in a way where you provide a background which sort of tees up the reason why you have an invention in the first place. You couldn't find it, nobody else made it, nobody else knew how to do it. Then you give a summary, which basically is the description of the scope of your particular claim, because you may be talking about a part on an automobile, and there may be a 10-page workup to what all about automobiles, but you come down to the brake lines or something like that. It's inventions. Right? So the scope of the invention is summarized. You get the drawings that show basically would teach anybody who's skilled in the art. And by skill in the art means has to be an expert in that field. If I could walk up and pick up a patent and not know how to make it, that doesn't mean it's an invalid patent. As long as somebody who's skilled in that art would be able to practice the invention. Now, we talk about it in terms of that's protecting for 20 years from filing date is the term of patent, your invention, right? That doesn't mean that you have a right to make it. Kind of implicit, but the operative word there is exclude others. Okay? Excluding others means basically it's a ticket for a lawsuit. You can enforce that in federal court. As I said, people don't like to get letters from me saying you're infringing the patent, because that automatically is either going to cost them legal fees in terms of reviewing it, or if they would ignore it and get sued, it will cost them even more legal fees to contest it. So you can exclude some people from making, using, and selling the patented invention in the U.S. Now, we also do foreign filings. You can file these patents worldwide. There's a system for claiming the priority. When you file in the U.S., you have a year in which to file what we use is called a PCT application. If you get into any serious technology, you'll find out what PCT is. That it's Patent Cooperation Treaty, covers most countries of the world, with the notable exception of Taiwan, which is a tech country, and a few small outliers. But the PCT is sort of establishes the priority that you started in the U.S., keeps it alive for an extra 18 months after the first year, so that you can, and when I say you, most businesses know their markets, or they're trying to assess what their markets are overseas, and by the end of that 30-month total period, they've at least got some sense of where their markets are going to be, who their manufacturing partners are going to be, where there's value in buying. So, in that case, you would also have the same rights as you do in the U.S. as far as excluding others from making, using, or selling that. The reason I bring up the international aspect of it too is a lot of people are worried, well, what if the Chinese knockoffs try to import it into the U.S.? Do I have to go to China to get a patent? You do not, because they can't make it, they can't import it into the U.S. Now, they can make it in China and sell it in Australia, so you have to protect it where your markets are. And you've probably all heard that China is not known to be very forthright when it comes to protecting intellectual property. I mean, we've been dealing with that for 20 years directly. When I remember they were taking out full-page ads in the Wall Street Journal saying how in China they've decided to basically support intellectual property rights. And I think there's still some issue whether or not they're enforcing it. In our experience has been you can enforce patent rights in court in China if you have a Chinese partner. If you're a foreign national and you go into court directly, you're going to have a tough time. It just, it's a road game. So, but that's the international aspect.
How expensive are those foreign patents?
Well, Europe is the primary one that we go into, and it's relatively expensive, more expensive than the U.S. But per country it is not, because it's a regional application that covers all the European countries plus some extension states, they call them. So it really, I think it's up to 52 now. It covers the Balkan states, Romania. There's a whole long list of them. But, so it's generally worth, if you're going to be in the European markets, it's worth doing. But we'll file in China, Canada. But they're all over the board. But I would say Japan's very expensive. China, Korea, Canada are relatively inexpensive. I would say dollar-wise, once you've established your patent filing here in the U.S., you're probably talking $3,000 to $5,000 to have a foreign agent file your foreign application. None of it's cheap, I should say. But $3,000 to $5,000 sounds like a lot of money, but relatively speaking, it's not too bad. Now, if you're going into Japan and Europe, you might be talking $10,000. And of course, it depends on complexity too. Like a complex drug patent or integrated circuit patent or something like that could be at the high end of that, above that. So. And then, to top it off, once you get a patent in a foreign country, you have annuities that you have to pay every year. It starts at $1,000, $1,500 annually, and keeps ratcheting up because if you want to keep that patent in force, they're going to make you pay the price. And a lot of times the business decision is after so many years, if you're not exploiting that technology and generating license fees, you just let it go. So patent registration is, it's not an automatic registration. There's an examination process. They claim, I think, 16 months until you get your first office action. So it gets into the patent office, goes into the queue, they assign it to an examiner, and over a year later, you might get an office action. I've had office actions, first office actions come in 3 years later. Then you're probably going to be looking at an office action that says all of your claims are rejected, which is not good news to my clients. But I have to explain to them that's pretty typical. That doesn't mean that you're out of the game. You have to possibly amend your claims, and I'll talk a little bit about claims later, but basically the scope of your protection is defined by these claims. We try to write them as broadly as we think we can get allowed, but in doing so, sometimes the examiner finds prior art, which are earlier filed patent applications, that might overlap the territory that you're trying to protect. So so they'll cite this patent, and then we have to look at it and say, well, yeah, maybe we overshot our mark there, and we'll have to back it off a little bit, and we might add some limitations that narrow the scope of that, so it's not covered by these other patents. So, so the examination process, beginning to end, if we file an amendment, the examiner accepts our amendments, then you're talking 3 years of patent pending before you actually get an issued patent. You can't sue anybody on a patent until it's issued, so those 3 years are really the window where competitors can, if they want to, knock you off. Now, the bigger companies won't do that because they know they don't want to develop a market or develop a product and get into a market that they know they're going to have to leave as soon as the patent issues. And they could be exposed to interim damages too if somebody would want to force that issue. It's not usually done just because of the cost of litigation.
Do you have any recommendation for those several years where you're kind of waiting for your patent to come back?
Well, you mark your product patent pending. It's about all you can do.
But, so if it's patent pending, does that offer you the same protection as having a patent?
Well, what that patent pending does give you provisional rights, provided that the claims are substantially the same as what issued as they were when they were published, first published. So there is some level of protection. Well, the terms of the non-disclosure, generally, they can be flexible. I usually put 2 years before anybody is allowed to disclose anything. But you can make them permanent if you want. But there's always, the release would be if it becomes public information in the meantime, so it's no longer confidential, then you can't hold somebody to a confidentiality agreement on an application that's been published. So, but 2 years is generally a good rule of thumb. So these are the ways that companies protect the IP. The copyright and trademark registrations, patents, keep your trade secrets. This is where we talk about non-disclosure agreements, and watch notice services are good. Occasionally I'll do some monitoring of competitors on patents for my clients. And you know, they come up with some interesting overlap sometimes. More often you see it on the trademark side where you've got a name that we get watch notices from all over the world, and some of them are irrelevant, but every once in a while you'll see somebody try to encroach on your territory, and that's when you can file opposition proceedings to stop them from getting trademarks that they apply for. Yes?
I go back to the disclosure part of it.
The non-disclosure?
Yeah, the public disclosure that you were talking.
Yeah.
So our students, we do these pitch competitions throughout the year. They do
Yes.
them both here, and they travel nationally, internationally. And we always face that, what constitutes a public disclosure? How much should they be disclosing? Should they take NDAs with them everywhere they go? Can you talk a little bit about that?
Yeah, legally a disclosure is a disclosure. So if you disclose it under term where there's no non-disclosure agreements, and of course, you know, if you're at the Monroeville Mall where everybody's walking in and out, it's almost impossible. If you're in your factory or on your own premises and you can hand them a form saying you got to sign or we can't let you in, then it may be easier to get them to sign. But you know, without that protection, the only other thing that I would say is you can always file a provisional application before you do it. And it's probably not practical for college students to come up with the money to file a provisional patent application. But you can also withhold the key elements of the invention. In other words,
Secret sauce.
Exactly. You can give them the black box and you can show what the end product looks like without disclosing all the details that you mentioned. But you got to be careful with that. It's not. You'd be surprised what they might be considering. Could be considering, and some of that gets published as well. So whether it's videoed or just an article in the local newspaper about the trade show that was going on. There's always issues, and my business picks up just before trade shows because people call us and we've got this new product, we want to show it, they're all excited about it. Salespeople aren't going to hold off. So typically it's a Friday afternoon, I have to have it filed by Monday morning, so I end up working all weekend, but the only real protection is if you have patent pending, the safest protection. Okay. Marking the packaging, again, there's your copyright notice. It's always good to keep that language handy, mark it on anything. Trademark notices. Usually this type of notice is the kind you'll see on a web page or published literature, maybe brochures that go with it. But the best way to mark a trademark is stamp it right on the packaging, even on the product if you can. And you can mark your patented products the same way. You've probably seen some of them where the patent number can either be stamped in right into the metal of the product, or certainly on the literature, like the operating manuals and things like that. These things, I think they're pretty self-explanatory. If you're in business, you're generally got your eye on your competitors anyway, so you just want to be aware. And a lot of the engineers that I work with will routinely go through their list of competitors, see what they published. If they published a patent application or got a patent issue within the last month or 3 months, and keep up on that. Trade papers, magazines. Those are a double-edged sword because a lot of times you like to publish your information. It's good exposure for your company, but it also runs the risk of letting out potentially patentable subject matter that could be barred by the disclosure. I think most companies, we've done work with General Electric and Boeing and Sandia Labs, and all of them have internal controls on it. You are not to publish anything anywhere until you get the approval of the patent department. So they're pretty rigid about that. Other places are maybe a little looser on that, and sometimes things get out the door and shouldn't. I'd have to say, 30 years I've been practicing, people today are much more savvy about the IP stuff. They're not going to just go out and tell everybody. Yes, sir.
So, patent, how specific does it have to be? Because you said you try to make it as broad as possible and most times it fails.
Mhm.
So, what's stopping me from reading the current patent now and then changing a certain percentage of it and then reapplying it as a patent?
In fact, you may be able to improve on it. If yours is an improvement over theirs, that could be a patentable improvement. Sometimes the improvement patents are better than the underlying patents. So, but to your point about going as broad as possible, I was actually talking about the claims, the scope of the claims. Now, there are different components to the requirements for the invention. One, the patent application. One is the best mode, and the other one is enablement. So, in that part of the patent application, you have a lot of great detail. Okay. You may claim something very broadly, saying, I need at least one leg and at least one base for my chair. Okay. But in the patent specification, the preferred embodiment might be 4 legs and a flat base for my seat bottom and the back to support it. So the claim is just to that basic elementary structure, but the disclosure tells you all about how it operates and the best way to use it. So So there's more detail than just the broad scope. But you could take the Maglite patent, tear it apart and say, well, here's what they missed something. You know, here's what I can do better. And you can get a patent. Unless it's obvious. That's the criteria for a patent is novelty, non-obviousness. I think I'm missing one, but the ones that we probably like.
So who judge like non-obviousness? Because something might be obvious to someone else, but
Well, we fight over that all the time. The examiners think everything's obvious, and we have to prove to them it wasn't obvious. And, you know, it's funny because sometimes the document that they cite to us will basically support our argument that it's not obvious. Some of these arguments, some of the patents where they would say this is, your invention is disclosed, might say that if you would do it the way we've done it, we claim, it won't work. So we call that teaching away. And you can sometimes trap the examiners on that. But, you know, it's not always a guarantee that you're going to overcome those obviousness objections. So sometimes it depends on the level of the technology. Because if it's a bowling ball, there's not a whole lot of science to it. If it's a pharmaceutical compound, then you've got a lot more argument to work with. So, okay, so these market reviewing. Sorry.
The enforcement.
Yeah, so enforcing is the point that I was making about you know, the patent being basically a ticket for a lawsuit, because that's really the only way you have to stop it. And we send cease and desist letters out fairly often. Our clients receive cease and desist letters fairly often. So that's not an automatic either. I mean, if we get a cease and desist letter, my client wants me to look and say, do I have to stop making this? Now, I'll review the patent, and in some cases I might say, yeah, you better get a license to this or stop making it. Or, and this is not infrequent, is, you know, we would go through and maybe see that patent might be invalid, or the product that we're making doesn't infringe. And that's where, again, you go back to the claim language, and a claim might recite, you know, to use my chair example, at least one leg and one seat base and an arm and a back. Okay. Well, maybe our product doesn't have an arm, right? So if we made a chair without an arm, and that's in their claim, it's called all elements. All of the elements in the claim have to be met. So oftentimes we'll find that it doesn't infringe because it doesn't meet all the elements in the claim. The other thing is, it might meet exactly all the elements in the claim, but the examination, and I had this recently within the last year or two, the examiner, I don't think he even looked at the patent application. He must have been in a hurry. We find this, I worked with some patent examiners, former examiners, and at the end of September is their fiscal year end. Well, they get their bonuses and promotions based on how many counts that they do during the year. So you'll find suddenly at the end of August to the end of September, all of a sudden we get notices of allowance left and right. You know, we've been fighting over this for a long time, and now they're just going to send me a notice of allowance. But that's one of the factors you got to take into account. This particular one, the examiner didn't issue an office action or anything. It's like, filed the patent application. Within 6 months, they got a notice of allowance and they got the patent. Well, needless to say, they didn't examine the prior art. This was a pretty basic element. It had to do with an optical scope device and for a bow and arrow. And you know, they didn't even take into consideration all other kind of optical devices that may not be tied on a bow and arrow, but they're the same exact thing. So we reviewed it, analyzed it, and came up with an analysis that said it was invalid because they didn't consider all the prior art. So that's sort of the mechanics of what happens when you get a cease and desist letter. By the same token, when you send a cease and desist letter out, you need to review your own patent to make sure that there's no holes in there, because you're just gonna end up back where you started. If they can review that and say, look, it's not valid because, the most relevant art wasn't even considered. So that's what you do. Obviously, you can't even bother sending a cease and desist letter until you have a patent issued. This is publicizing enforcement of victories. We don't do that. That's just bragging. Minimize the risk of infringing. This is good practice. If you're going to, particularly if you're going to go out to market, and a big company is going to go national with a product, number one, you want to get clearance searches on all the trademarks that you might be applying for the product, and it's also good practice to do a patent review to make sure any patents that you have are valid and that you're not infringing somebody else's patents. Policies and guidelines, training about types of IP. Now, I think that's mostly done training the technical people. You should consider that broadly. It would be the marketing people, because they're going to have access to possibly technical information, so they're going to be loose with protecting the IP. But the best practice for technical employees, when I'm saying engineers, I mean anybody, could be programmers, anybody's going to have access to technical information, is on day one in the employment agreement to have the intellectual property assigned to the company. And that way there's no question. And the reason you do it on the first day of employment is because if you do that later, there has to be consideration, additional consideration, that to obtain those rights, because if there's no consideration, there's no validity to the assignment of the patent.